Canadian privacy laws generally don't have special or explicit rules for children's privacy, and the new proposed federal privacy law addresses kids' privacy, but in a weird way. In this video, I'm going to provide an overview of Canadian laws around kids' personal information and what changes we can anticipate. Hi, my name is David Fraser. I'm a privacy, internet, and technology lawyer with the Canadian law firm McGinnis Cooper. I also teach internet and media law at the Schulich School of Law at Dalhousie University. In this channel, I try to provide educational and informative content about Canadian privacy and technology law. You should check out the full disclaimer below, but you should know that I'm about to give you a high-level overview of a somewhat complicated and nuanced subject. Any opinions expressed should not be attributed to my firm or any of its clients. If you were to search all of the dozens of Canadian privacy statutes for the word child, children, or minor, you'd come up empty. Unlike in some jurisdictions, we don't have any specific rules in our statutes that spell out what can and can't be done with personal information about kids. That doesn't mean there's no difference between an adult and a child, but we do have to dig into the basic principles of privacy laws to find out where the lines are and what the rules are. A starting point could be that in Canada, minors are considered to be legally incompetent to agree to contracts until they hit the age of majority. That's either 18 or 19, depending on the province in which they live. Before then, their parents or guardians act on their behalf, but capacity to enter into a contract doesn't equate to capacity to consent to the collection, use, and disclosure of personal information. Consent is different from agreeing to a contract. In most cases where consent is a legal concept and capacity to consent is an issue, individual autonomy, decision-making, and dignity are implicated. We can think of consent to medical treatment or consent to engage in sexual contact with another person. In Canadian law, there are bright lines where the criminal code says a young person is deemed to be unable to consent to sexual contact, and that is to protect young people from exploitation. Privacy is about autonomy and dignity. It's about choosing whether to disclose information, with whom it is to be shared, and for what purposes. That consent has to be informed and freely given. Private sector privacy laws in Canada are based on this idea of consent. In order to collect personal information from someone, a business has to obtain the informed consent of the individual for the purposes of the collection, use, or disclosure. If the person was not able to make an informed decision, then the consent is simply not valid. From the organization's point of view, it's not about a magic age at which someone can consent, but it depends upon whether the organization can obtain this necessary informed consent. Under our general federal privacy law, consent will only be valid if it's reasonable to expect that an individual would understand the nature, purposes, and consequences of the collection, use, or disclosure of their personal information. The Act does not differentiate between adults on the one hand and youth on the other. It turns on whether the person is able to understand the nature, purpose, and consequences. If they are not able to do so, the organization cannot get legally adequate consent from them. If they are able to give this consent, and they do so freely, then the consent is valid. The Office of the Privacy Commissioner of Canada, or the OPC, has consistently viewed personal information relating to youth and children as being of particular sensitivity, especially the younger they are, and that any collection, use, or disclosure of such information must be done with this in mind. The OPC also generally takes the view that children under 13 can be presumed not to be able to consent on their own behalves, so parental consent should be sought. Youth between 13 and the age of majority generally can, but the organization has to take special care regarding information about youth. The new proposed replacement for PIPEDA, called the Consumer Privacy Protection Act, which is only just proposed and not yet passed, expressly deems information about youth to be sensitive. Section 2 sub 2 says, quote, "For the purposes of this act, the personal information of minors is considered to be sensitive information," unquote. So if information about kids is considered to be sensitive, what does this mean? In Canadian privacy law, the concept of sensitivity drives a couple of important principles. The first one is that the form of consent obtained has to be commensurate with the sensitivity of the personal information. You generally can't use implied consent for sensitive personal information. It would also be hard to be sure that a young person understands what's going on, which is also a prerequisite for using implied consent. So where the information is sensitive, consent has to be express consent. You have to clearly set out the purposes for the collection, use, or disclosure, and plainly ask for consent, yes or no. And with kids, you have to be sure that the individual understands what they're being asked to consent to, and what it all involves. This means plain language explanations to the relevant kids. It can also mean getting consent from the young person's parents, but you need to be satisfied that you're getting the proper consent from the right person. Information that is sensitive also has to be protected by greater safeguards. The proposed Consumer Privacy Protection Act also includes what I think is a very good provision. Young people, if they're capable of making their own privacy decisions, have a veto over any decisions made by their parents on their behalf. Section 4 sub A says, quote, "The rights and recourses provided under this Act may be exercised, A, on behalf of a minor by a parent, guardian, or tutor, unless the minor wishes to personally exercise those rights and recourses and is capable of doing so," unquote. Now, it should be noted that tutor is a legal term for guardians under Quebec law, so it does not mean that the person who's helping your kid with math gets to consent on their behalf. So if a kid is capable of making privacy-related decisions and wants to, they are the one who has the rights and recourses under the CPPA. Otherwise, their parents or guardians get to make those decisions and exercise those rights for them. What this also means is that kids essentially get to veto decisions made previously by their parents, supposedly on their own behalf, but only when they're competent to do so. This is because Canadian privacy law includes the right to revoke consent that's been previously given. So if a parent has consented on behalf of a kid, when the kid is old enough, they can choose to revoke or withdraw that consent. So if a kid is too young to make his or her own privacy decisions, does that mean that parents should throw common sense out the window and post all over social media? Now, that's a big no from me. Parents do get to make decisions for kids up to a certain age and up to a certain point of risk to the child. I've never heard of the state intervening to protect the privacy of a kid from a parent who is an oversharer. While I think this sort of stuff may be harmful to kids when it goes too far or becomes exploitative, there isn't a mechanism that I see in Canadian law, short of the child protection system, that would intervene. Parents should be sensible about what information they post about their kids online. Most responsible social media companies do have mechanisms by which this right can be exercised by kids. Now, before I wrap up, it's probably worth noting that there are other areas where the law steps in to protect the privacy of young people. For example, we have the Youth Criminal Justice Act, which protects the identity of young people charged with crimes. Young witnesses get additional protections in our courts. The courts also have common law jurisdiction to protect the privacy of kids when they are asserting their rights in the legal system. Child protection statutes universally protect the privacy of children. I hope this has been interesting and useful. I try to put up a new video every week or so if you're interested in this sort of content, please click the like and subscribe buttons. Also leave a comment if you have any questions or if you have any suggestions for other topics to cover. And of course, feel free to share this with anyone who you think may be interested in hearing about developments in Canadian tech and privacy law. Thank you very much for tuning in.